Welcome to the Legal Notepad. If you're an attorney, I have a special editor's note. This note has been added after the recording of the episode. The podcast, the episodes, they're always free. However, if you want CLE credit, the Kentucky Justice Association has submitted the podcast to the KBA for CLE credit. In order to get credit, simply go to KentuckyJusticeAssociation.org, click on the Education and Training tab, then click on Podcast and add it to your cart. That being said, let's jump into our episode.
Dear Kevin and Rob, I was reading in a journal that every year there's a lawyer that makes the Fratzke mistake. It went on to say it's simply unbelievable lawyers keep making the same mistake today. What is Fratzke, and how can we not make the same mistake?
Welcome, everyone, to Episode 4 of the Legal Notepad. As you know, my name is Rob Mattingly, and I'm here today with my great friend Kevin Burke and my amazing paralegal Lauren Hincks, who you just heard read the question of the day. What is the Fratzke trap, and how do we avoid that trap? As a recap, in the last episode, we covered a topic that arises with some frequency. That question being, can a defendant make a plaintiff stipulate away liability? Today, we're moving forward with another trap that appears way too often. The Fratzke trap. And by the end of this episode, everyone should have a really detailed understanding of how Fratzke came about, how it has changed over the years, and how you can avoid that trap. As with all our podcasts, if anyone would like the case file, which will include all of the rules and the cases that we discussed today, just send an email to me at robertmattinglyattorney@gmail.com or to Kevin, whose email is kevin@burkenil.com, and we will happily send you the case file free of charge. So let's move on to the question of the day. What is Fratzke, and what can we do for making the Fratzke mistake? Kevin, why don't you take it from here?
Yeah, so Fratzke is named after a Supreme Court case called Fratzke versus Murphy. And I'm just going to give you the site so our listeners have that available. It's 12 Southwest 3rd, 269. And it's a case from the Kentucky Supreme Court that was decided in 1999. And Rob, do you want to talk a little bit about the facts, and I'll handle the analysis, or
Yeah, let's do that. That's so for those that don't know, Fratzke, it's an auto accident case. There was a pedestrian, and the pedestrian was actually walking the picket line when they were struck by a motor vehicle. So subsequent to that, litigation was initiated, and all the natural stuff that happens, it did happen, interrogatories, depositions, all those things. But this case proceeded to trial. And during opening statement, the lawyer for the plaintiff began talking about the damages that they would seek at trial and asked the jury to award. And at that time, the defense lawyer objected and said, well, hold on, Judge. We were never made aware of these damages. The damages weren't itemized. Let me give you more specifics. So, for example, they said, you didn't tell us the amount you were going to ask for medical bills. You didn't tell us the amount you were going to ask for pain and suffering or lost wages. And as a result of that, the plaintiff can't talk about it during trial or ask for it at the end of trial. And what no one knew at the time is that was going to start a long process that would create an entire body of law in Kentucky. And trust me, you never want to be the one that has an entire body of law made about you. And now here we are today talking about Fratzke problems and mistakes that lawyers make. So Kevin, why don't you run with it from there?
Sure, yeah. And, Rob talked a little bit about the factual and the procedural history. It is important to recognize that, Fratzke the Fratzke case went to trial in 1995. So at that time, there wasn't the body of law that's built up because of the Fratzke case and afterwards. So, when you read these cases, sometimes it's easy to say, oh, this should have, I can't believe this or that. And as understand that the litigants are there in real time in 1995, trying to make their way through what was then an uncertain path. And only later, years later, would the Supreme Court say, oh, it was clear it was this. well, everything's clear in retrospect. But
Well, it obviously wasn't clear to everybody.
right, that's right. But the opinion makes it so clear that but it really wasn't at the time of trial. So, as Rob mentioned, this case went to trial. There wasn't an itemization of damages, as Rob mentioned. So the defense objected and said we're entitled to an itemization of damages under a civil rule. And the civil rule is CR 8.01, specifically paragraph 2 of that rule. And said, we're entitled to that. We're entitled. We sent an interrogatory to the plaintiff's counsel requesting an itemization of damages, and according to that rule, we were entitled to get an itemization back. And because we didn't get that itemization, Judge, then the plaintiff is limited to effectively $0. They don't get any money above what they claimed in that interrogatory answer. And so that's a strict rule and it has to be followed. Well, the trial judge said, no, that doesn't really make a lot of sense to me. So keep in mind, the trial judge in this court didn't think that rule made a lot of sense. So the case goes to trial. A jury returns a verdict in favor of the plaintiff for compensatory damages for medical expenses and the like, pain and suffering, that sort of thing, and it goes up to the Court of Appeals. The defendant appeals that. The Court of Appeals agrees with the trial court. It says, you know what? That doesn't make the trial judge allowed it to go to the jury. We don't see a problem with that. That's fine.
And let me stop you there. So in the real world, what happened is this plaintiff just tried a case. And in his opening statement, they tried to throw out his entire case, essentially, by saying he couldn't have damages. And the trial court said, no, doesn't make any sense. We're going to let you have it. And the plaintiff's lawyer goes, whew.
That's right.
All right, I can get this thing to a verdict. I didn't mess up. Goes to the Court of Appeals. And the Court of Appeals said, yeah, you know what? It's fine. Plaintiff lawyer says, whew, I didn't mess up. But the Supreme Court takes it.
Well, and actually before that, so let's go back to the Court of Appeals. The Court of Appeals affirmed initially, but then on reconsideration, changed the outcome. So the Court of Appeals first says, plaintiff, you didn't do anything wrong. We're going to allow the jury verdict to stand. And then on reconsideration, based on a case that had just been decided, called Burns versus Level, the Court of Appeals says, you know what? Defendant was right. And plaintiff, you're wrong.
So this issue that's so clear before Fratzke, the trial court rules in the plaintiff's favor, the Court of Appeals initially does, then they reverse themselves. That's how clear it was.
Exactly.
And now the plaintiff's going, well, gosh, I hope the Supreme Court decides to take this case.
That's right. And then the Supreme Court does take the case. But the Supreme Court, we'll say, doubles down on Burns versus Level. So here's the interesting thing. The plaintiff had actually used the reasoning in Burns to say, well, in that case, the trial court retained discretion to grant, in that case, the court granted a directed verdict based on CR 801 and said, I'm granting a directed verdict to the defendant because the plaintiff didn't itemize damages. But the court in Burns said, well, the trial court had discretion to do that. So the plaintiff in Fratzke says, well, that's important because my trial judge also had discretion to allow the case to go forward, right? So both sides are really arguing over this Burns case. And the Supreme Court says, well, you know what? Not only were we right in Burns, but you have to strictly follow the language in CR 801. And because of that, the court ended up affirming the Court of Appeals, but actually created a pretty harsh rule that requires the trial court, at least in the absence of a motion for leave to supplement your interrogatory answers, created a pretty harsh rule that says if you don't do that, you're bound by the last number that you indicated in your interrogatory answers, and that's caused a lot of problems since that decision.
And in this case, it was bad for the plaintiffs because they just never answered that interrogatory answer. Or I think they answered it in this particular case, like near the end of the trial or something like that. But certainly pre-trial, they never answered it, and therefore they got no damages.
Yeah, and what's interesting is procedurally, so the defendant raises this objection under CR 8, and the plaintiff actually says, "Well, here's my judge. If they're arguing over this, here are my damages. I'm going to give you a list of my I'm going to give the defendant a list of damages here," and the Supreme Court said that wasn't enough. The plaintiff needed to file a motion for leave to supplement those interrogatory answers. It wasn't enough to supplement them. You had to file a motion for leave to do so. So,
And that's because of the trial order, right?
well, it's because of what the court interpreted CR 8 to require that you had to file a motion for leave to supplement your interrogatory responses, and created what the court even agreed was a strict rule to do that. But then includes this language in the opinion that we're not including a landmine in civil litigation. Well, I think whenever you create a strict rule like that, a one-size-fits-all policy, then you're putting a landmine in civil litigation.
I did read on page 3 of the opinion. It says, quote, "Contrary to the argument made by the dissent, our opinion today does not bury a landmine in civil litigation," end quote. I do hear you two talk about this a lot, specifically at the Kentucky Justice Association convention last year, which was also the year that Rob was president, by the way, about these gotchas. And this seems to be one of those. Would you agree?
Yes, I agree, and I mean, I think that the subsequent case law has, although it doesn't, the majority opinions don't say that. I think that even the Supreme Court and the Court of Appeals, through their analysis, has acknowledged the harshness of this rule and tried to mitigate the harshness of the rule through their analysis in subsequent cases. So, and the dissent, there were 2 dissents in Fratzke, and in both of those dissenting opinions, they highlight the harshness of this rule. So 2 out of 7 justices on the Supreme Court are really flagging this and saying, this is a huge problem, this shouldn't be, it's unnecessary, and the rest of the court is saying it's not. So, even Supreme Court justices are arguing against each other to say, this is really bad, this is going to cause problems, it's unnecessary, and the other is saying, no, it must be harsh. Well, they're the Supreme Court. They can decide whether it's harsh or not. And in this case, a majority of the court said it should be harsh.
It's up to them.
Correct.
Well, let me take my listeners to where we are, which is we're dealing with Fratzke, and this is the Fratzke opinion that came down. And in essence, what you need to know, and I hope you do know if you're listening to this, is you need to itemize your damages. And in the real world, in the litigation world, you're going to file your lawsuit and you're going to get interrogatories, and most of the time it'll ask you about these, what are you claiming? And my personal opinion is just go ahead and ask. Just go ahead and fill in or answer those. Go ahead and just fill in what you're going to ask for. Say what your medical bills are. Say what you anticipate your future medical bills are. Say what you believe your lost wages to be. Say what you're going to ask for pain and suffering. You can go back and amend those later, but don't wait. My advice is let's just get them in, because right now, even though there's a couple dissenters in the Fratzke opinion, the answer is it's a very harsh rule, and if you don't do that or if you forget to do it, you could end up essentially having a negative outcome for your case.
And just to follow up on Rob's point, this is, it's important in these types of situations to do, you don't want to do just the minimum or what you think is the minimum on this. Go ahead and disclose all of your damages in your interrogatory answers. Be vigilant about updating those amounts, and do that. You never want to be in a position where you're wondering whether you're close to that line of, have I done enough? Have I done enough? Don't ask yourself that question. Assure yourself you've done enough by being vigilant about answering your interrogatories and itemizing damages.
So for our listeners' sake, we've now talked about Fratzke, and that was the year 1999, the Kentucky Supreme Court. There's lots of Fratzke cases that have occurred since then, but for the podcast purpose and to keep us on point, there's really just 4 that we want to briefly go through that Kevin wants to talk to you. So why don't we give an outline, Kevin? The next 4 cases, again, there's other Fratzke cases, but the 4 that we want to talk about today, post-Fratzke, why don't you give the name and the case sites in case our listeners want to look them up or get them. Again, listeners, remember, you can email either of us, and we'll send you the entire, all the notes and all the cases, et cetera. But what are the 4 other cases that we're going to talk about today?
Yeah, thanks, Rob. And the 4 cases that I've highlighted, and there are unfortunately many Fratzke opinions, but the 4 that I want to highlight, the first one is LaFleur versus Shoney's. That's 83 Southwest 3rd, 474. That's a Supreme Court case from 2002. And the next one is Prater versus Castle, 139 Southwest 3rd, 921, and that's a Court of Appeals opinion from 2003. And then Tennell versus Talai, let me spell that last one, it's Talai, 277 Southwest 3rd, 248, and that's a Supreme Court opinion from 2009. And then to round it out, we have Chesapeake Appalachia LLC versus Collins. Now, this is an unpublished opinion, but I'll explain a little later why it's important. And so what I have is a Westlaw site for an unpublished, because it's an unpublished opinion, that's all we have. And it's 213 WL 645 913, and it's a case from the Kentucky Court of Appeals in 2013.
So we have 4 more that we're going to cover. We won't go into quite as much detail as we did in the Fratzke one. But Fratzke, 1999, we get to the LaFleur's case. We're going to talk about that now. We moved to this opinion coming down in 2002. Kevin, what do we need to know about LaFleur?
Yeah, so LaFleur versus Shoney's is actually a slip and fall case involving what was the 5th quarter at that time. 5th quarter is near and dear to my heart.
I remember the 5th quarter.
I was a busser at the 5th quarter.
Really?
So
Okay.
yeah, that was
right.
my first job. So this was a slip and fall case at the 5th quarter, Shoney's restaurant, and this one was a little different from Fratzke in that there was a trial court order that ordered the plaintiff to itemize damages within 10 days of trial. There was also an interrogatory submitted by the defendant in this case, but independent of that interrogatory, the trial court said, here's a deadline, itemize your damages within 10 days of trial. The plaintiff, in fact, filed an itemization, but 5 days before trial.
So they didn't answer the interrogatories.
Right.
Originally, when they came out early in litigation.
That's correct. And instead, within 5 days, let me go back. There was a response in response to the interrogatory answers, but it was only for a small sum on the damages. There was within 5 days of trial, the full damages were disclosed.
So they answered the interrogatories,
Correct.
but it's early in litigation, and they put a smaller number than they want to claim. Maybe they didn't know how much they were going to claim. Maybe they didn't know what all the injury. Whatever reason they decided, they only put a small number in their itemization of damages in their interrogatories.
Correct.
But up to 10 days from trial, they have an order that says if you're going to change them, alter them in, whatever you're going to do, you have 10 days. And we all have seen trial orders that give us a time to itemize our damages. And they don't do it within 10 days. They do it 5 days from trial. 5 days late under the order.
That's right.
Go ahead.
And so the defendant, then it gets to trial, and the defendant tells the court, well, this is a Fratzke violation. The plaintiff is limited to the lower amount that they've claimed. They can't collect these additional elements of damages because it violated the trial court order. And again, like the trial judge in Fratzke, the trial judge said, I'm just going to let this go to trial and let the jury award the damages because that reasoning doesn't make a whole lot of sense. You know, it's not like Fratzke. It's a little bit different from that. You know, I had the trial court. I created the trial order, and I don't see any prejudice here. So I'm going to let it go to a jury. And the jury awards damages to the plaintiff, just like the jury awarded damages to the plaintiff in Fratzke.
And in this case, the trial judge, I guess using their discretion, said, I said 10 days. He did it in 5. That's good enough. There's no real prejudice. And the jury awarded damages.
That's right.
Well, what did the court do with that?
Yeah, so it gets up to the Supreme Court.
Of course it does.
And, right. And the Supreme Court says, no, this is effectively just like Fratzke. And it doesn't matter whether yes, in Fratzke it involved a failure to answer interrogatory answers, but here it's the same because it was a trial court order that required you to itemize your damages within 10 days. The opinion also points out that the remedy would have been to move for leave to file interrogatory answers. The plaintiff should have done that. But the plaintiff, of course, did file an itemization. There really wasn't any prejudice to any party. Even the trial court didn't believe there was prejudice. But the Supreme Court in LaFleur says, no, you have to move for leave to amend your interrogatory answers, that's the only surefire way. And then the court has the discretion to grant leave. And if you do that, if you jump through those hoops, you'll be okay. But any other way, maybe not.
So, you know, it sounds like such a technicality because the plaintiff did amend their interrogatory answers, did file this itemization of damages, but they just forgot, and the court accepted it, but just forgot to say, oh, Judge, I'm motioning to allow you, for you to say I can do it.
That's exactly right.
So never find yourself in this position. But if you do, file a motion and ask the court so you have an order saying now the judge is using their discretion. Is that the remedy?
That's exactly right. And what I tell people who call me or email or text in situations like this, said, you know, just imagine that the person reviewing your case is adverse to you. Just pretend that. I'm not saying that they are. Not saying the judges or anything are against you, but just pretend they are. How would they handle this if they were out to get you? And then act accordingly. So the only way that these cases say you can get around Fratzke is by filing a motion for leave. And they say, Kevin, but I included it in my jury instructions. Kevin, I amended my complaint, or I did this or that. And I say, but what does the case say? The case gives you a path. Follow that path. It may make sense what you're saying, but follow that path.
Because you have to strictly follow this.
Right.
So let me bring our listeners back. First piece of advice, always just answer those interrogatories, the damage interrogatory, as soon as you get it. Answer that, and then you don't have to worry about this as much. If you don't do that, and you get up to your trial order, and now you've gone past that date, always file a motion asking to amend the interrogatories, asking to extend that trial order date, because the judge has discretion, but most lawyers forget to file the motion. They just do it. There's usually not an objection. The court says, yeah, it's fine, but there was never a motion. 2 takeaways, and the second one is file the motion and ask to file them late is what you need to do.
Absolutely.
Okay. So I think all that makes sense. Have we covered LaFleur at that point in time?
Yes.
Okay.
Yes, and as Rob said, I'm his paralegal, and most of our cases are in litigation, so I'm familiar with discovery, receiving discovery, answering sets of interrogatories. I help answer discovery with Rob. So almost every single set that we receive, I expect to answer that question of itemize your elements of damages. But every once in a while, we'll get a set where it's not included. And I know how Rob and I would handle that matter, but I want to get your feedback whenever you're faced with that scenario.
What I recommend to folks is always file an itemization no matter what. Now, even if there's not an interrogatory question along the lines of itemization of damages, usually there will be a trial court order, like there was in LaFleur, right? So that was an independent order from the trial court that said, I want your final itemization within 10 days of trial. So follow the trial order, but even if there's not a trial order or an interrogatory that was sent to you, go ahead and file an itemization of damages, because you'll never go wrong in that circumstance. And this shouldn't be a situation where there's no strategic advantage to hiding the ball on damages at that late stage, right? So go ahead and disclose all your damages. You'll never go wrong that way, whether you got an interrogatory answer or whether there's a specific trial court order on that issue.
And I think that's important for so many reasons, but another reason is sometimes you find yourself in this situation. They didn't ask the damage question in the interrogatories, and the court didn't issue a trial order. And I have been involved in litigation which they didn't issue a trial lawyer. And fortunately, I know, but other people have forgotten that sometimes you got to check the local rules, because the judge doesn't issue the trial order because the judge knows there's a local rule requiring it.
That's a great point, Rob. Yeah, the importance of the local rules is, I mean, you have to, they're rules just like every other rule, but sometimes we forget that. You have to read the local rules whatever county you're in. Make sure you're aware of that, because, as Rob mentioned, you might not get a specific trial order setting forth deadlines, but those are in the local rules, and you have to follow that.
So look, if you always disclose, itemize, don't just say one big number, but itemize medical bills, future medical bills, lost wages, future lost earnings, pain and suffering, whatever it is you're going to ask for, itemize it, and itemize it as soon as you can. And then you won't violate interrogatories, trial orders, or local rules. Well, let's keep walking our listeners through. Remember, there was the Fratzke case and 4 others we wanted to talk about. So we talked about Fratzke, which was 1999. Kevin then explained LaFleur, which is 2002. And then as we talk about this body of law, we get to 2003 when the Prater case comes down. Let's keep moving. Tell us what we need to know about that.
So the takeaway from Prater, we don't need to go into the facts or much of the procedural history of it, but the difference in Prater. So it was this. The defendant, it gets to trial. The plaintiff hasn't provided an itemization of damages. The defendant objects and says, Judge, Fratzke, LaFleur, this case needs to, they can't claim damages effectively. The plaintiff does file a motion for leave to supplement the interrogatory.
So they're following LaFleur so far.
They are. And the trial court says, well, I'm not sure I can do that, because I read LaFleur and I read Fratzke as requiring that motion for leave before the defendant objects. Okay? So it goes up to the Court of Appeals, and the Court of Appeals says, well, that doesn't really matter. The trial court absolutely has the discretion to consider the motion for leave to supplement. So keep in mind, this is a case where the plaintiff appeals to the Court of Appeals, and the Court of Appeals reverses and said, trial court, you got it wrong because you needed to at least consider the motion for leave to supplement the interrogatory answers.
So in the trial court, the court says, I'm not ruling on this motion because the motion, well, I'm denying it,
Correct.
But I'm denying it not on the merits, but because it had to be filed before the defendant objected.
That's exactly right.
So they're dealing with all of that.
Yeah.
The Court of Appeals says, no, it doesn't matter that they filed the motion after they objected. You need to rule on the motion, on the merits of the motion. Can they do that?
That's right. And I think Prater, Prater was a 2003 opinion from the Court of Appeals. I think this is where you see the court, an example of where the court is kind of going in the other direction on Fratzke to mitigate the harshness of the rule, right? Because let's face it, what the Court of Appeals said here was, court, consider this motion. Well, it's now reversed. It's sent back to the trial court. Well, Rob, is there a trial date at that point? There wouldn't be a trial date, right?
That's right. There's no trial date.
There's no trial date, It's just the court has to reschedule it for a trial. So why
Reissue a new trial order, probably.
Right. So why wouldn't the trial court grant that motion for leave at that point? You see? So it really, I think Prater is a good example where the court, said this has gotten out of control. The court, you need to consider this. But basically, really, that message is, court, do the right thing, grant the motion for leave, and get this case to a trial on the merits.
And the takeaway here is that the plaintiff in this case had either read LaFleur or got lucky and did what LaFleur said, but they did file the motion. That's exactly what we talked about in LaFleur. They filed the motion, and as a result, the plaintiff ended up being okay in the end. They had to go to the Court of Appeals because it was a little unclear, but they were okay in the end because they're following the advice that Kevin is giving you today, which is if you forget to file your itemization of damages, file a motion asking for leave to do it. Don't just do it. And Prater's the perfect example of why that's good advice. Pretty fair?
That's right.
So we're again covering 4 cases after Fratzke. Fratzke 1999, LaFleur 2002, Prater we just talked about 2003. And then we get this 6-year gap before we talk about the next case that Kevin wants to talk about, which is 2009 and the Tennell case. And why is that one important to you, Kevin?
Well, Tennell, as Rob mentioned, was a case decided in 2009, but I also want to highlight something that happened in between Prater, 2003, and Tennell in 2009. CR 801 was amended in the middle, in between those 2 cases. So the CR 801 paragraph 2 is the genesis of the Fratzke opinion.
And that's where you got itemizer damages.
That's right, and it still says that. But it added this language to the rule in 2006. It said, provided, however, that the trial court has discretion to allow a supplement to the answers to interrogatories at any time where there has been no prejudice to the defendant. That's important because what it did basically in Fratzke, LaFleur, Prater, where it says the plaintiff must move to supplement the interrogatory answers, it just put the plaintiffs on notice in the rule change to tell you how to go about doing that. And it gives a standard for the trial court. It says, 1, was there a motion to supplement the interrogatory answers? If so, was there prejudice to the defendant? And it authorizes now the trial court to allow that amendment and gives a standard for it.
Yeah, so if we're playing this through, when Prater went up because the trial judge said, I don't know that I can do this. The defendant already objected. And the Court of Appeals, of course, as you just said, sends it back down and says, yeah, you can do that. Use your discretion. And this is kind of saying, Judge, when you're faced with these, you got some broad latitude, essentially saying you should probably go ahead and grant the motion and let them amend it.
There you go. And the rule change just basically includes that, spells it out for people. If the cases weren't clear enough, now there's a rule change that says exactly how you do it and gives a standard for the trial court. So
file the motion, though. That's the key.
File the motion. Always file the motion. Doesn't matter whether you believe the defendant had notice of every damage, even down to the single dollar you're claiming. File the motion.
Because you're probably going to win the motion.
That's it.
All right, well, let's go to 2009 and Tennell.
And Tennell, okay, so this is a little bit of a different case. It was a default judgment case, so liability was conceded because it was a default judgment. But even if you get a default judgment, as we know, there's still a hearing on damages. So the defendant is entitled to a hearing on damages, on liquidated damages, compensatory damages, and the like. And in this case, you have the defendant, after the default judgment, sent an interrogatory to the plaintiff's counsel saying, hey, for this upcoming hearing on damages, I need you to itemize the damages you're claiming.
But now all of a sudden there's a default judgment entered, and now all of a sudden the defendant or defendant's attorney gets interested and says, we better do something because now we have liability against us. So there's actually involvement at that point.
That's exactly right. There's involvement by the defendant where there wasn't on liability, sufficient for the default judgment, but on damages, they care now.
Well, come on, Kevin. I don't have to answer that. We're in a default judgment hearing.
Right.
Now,
That's exactly right. As the plaintiff,
I'm moving on.
You think you're in really good shape, and you're like, hey, look, I'm just going to a damages hearing. What do I need to do? I just need to show up, get the money, and we're good. Well,
But that didn't work.
that didn't happen. So the plaintiff's attorney doesn't answer the interrogatory answer, but there's also a deposition. The defendant takes the deposition of the plaintiff, and in that deposition doesn't question the plaintiff about damages or the itemization. And so this case eventually gets to the Supreme Court. The Supreme Court says the entry of default was okay, but let's talk about this damages issue and whether there was a Fratzke violation.
Which you never want the Supreme Court to bring up. Let's talk about that Fratzke issue.
Right. You never want to be in that position. So the Supreme Court gets it, and they say, well, look, it's clear that the plaintiffs didn't answer that interrogatory question. But there was a deposition that the defendant took, and the defendant could have asked questions about damages, but the defendant didn't. So the Supreme Court in 2009 says the defendant waived Fratzke by failing to ask questions in the depositions. Now, if you compare this opinion in 2009 with Fratzke in 1999, it's pretty hard to reconcile. Fratzke says it's strict compliance with CR 8, and you have to answer the interrogatory, and you can't do it any other way except to move for leave. Here we are in 2009, and the Supreme Court says, well, you could have asked this question in a deposition. It doesn't really matter. You didn't ask it, you didn't get an interrogatory answer, and so you've waived Fratzke. Those seem at odds with each other.
I don't want to find myself in a position trying to rely on that.
No, you don't. And it ended up for the plaintiff. It ended up okay because of the Tennell opinion. But it's another example where the Supreme Court, without saying it, tried to mitigate the harshness of the Fratzke rule and succeeded. Why? Because it's the Supreme Court deciding the case. So,
and they might have been a little influenced by the fact that there was a default judgment originally entered. Defendants didn't come forward and defend themselves originally. I mean, there's always these underlying facts that kind of that find yourself in that spot. But I think the takeaway here is always answer interrogatories. If you don't do that, always file a motion asking for leave. But if you don't do that and you find yourself in a really bad spot where you ignored all of Kevin's other advice and you find yourself in the Court of Appeals or Supreme Court, there's some hope that maybe the defense didn't ask your client that in a deposition.
that's right. And I,
But you don't want to rely on that.
You never want to rely on Tennell. You don't want to be in this position at all. You don't want to have to cite Fratzke. You don't want to have to distinguish Fratzke. You don't want to have to rely on Tennell. You don't want to have the defense distinguish Tennell. You don't want any of that. So the best thing to do is itemize no matter what, move for leave if you must. But if you're behind the 8 ball, if those ships have sailed, then Tennell is available. It's basically a fire alarm, but I would not rely on it. Don't put yourself in a position to have to rely on it.
You definitely don't want to do that. And I want to give our listeners a practice pointer because as someone that's I've been in 1,000 depositions. That's not an exaggerated number. I've been in 1,000 depositions, and oftentimes there's co-plaintiffs or other plaintiffs involved. And sometimes, not always, a lot of times defense doesn't ask the plaintiff about their damages. A lot of times they just don't. But occasionally they do. And I've heard other lawyers prepare their plaintiff client to say, they ask about their medical bills or their lost wages or really on pain and suffering a lot. And they say, I just don't know that now. I'm not sure what I'm asking for. I'm going to leave that up to my lawyer. And any of those questions, if asked, if you don't answer it, if you don't give a number, you're not going to have the Tennell out. You're not going to have everything's really gone bad. I'm throwing up a prayer at this point in time. You don't even have that.
Correct.
So you really need to prepare your client. That's just a great practice pointer in the event that you're asked those questions to give those numbers. Of course, you don't have to worry about any of it if you've itemized your damages.
That's
right?
exactly right.
All right.
And let me interrupt you for a second because I'm following this in regards to the compensatory damages, medical bills, pain and suffering, loss of wages. But what about a case where there is a claim for punitive damages?
Great question, and that really brings us to the fourth case after Fratzke, called Chesapeake Appalachia LLC versus Collins. The Collins case is, as I mentioned earlier, an unpublished opinion, but it addresses this issue, which is, must you itemize punitive damages in addition to your compensatory damages? So you've done everything you need to do with the compensatories. Let's say you have medical expenses of $50,000 and pain and suffering of $200,000, and you've done everything, but you say, well, wait a minute, does that apply to punitive damages too? Those seem different to me. You might say that as a litigant. Those punitive damages seem different to me, so I don't think I need to itemize those as damages. Well, the Collins case addresses that, and Collins is an unpublished opinion, but it collects a bunch of other unpublished opinions, and guess what? All of those opinions say you must, consistent with Fratzke, itemize even your punitive damages. Because while we talk about compensatory damages or punitive damages, what Fratzke addresses is unliquidated damages. And what the court in Collins said is punitive damages are unliquidated damages, just like compensatory damages. So you have to give a specific dollar amount in your itemization in order to comply with Fratzke. Again, are you going to find that in a published opinion? No, but it's unpublished, and why wouldn't you follow that, right? Why do you want to be the first published opinion?
We've said a couple of times, don't be the person that they make law.
No, you don't need to do that. Leave that to somebody else to blaze that path.
And we also know that the courts, as you've talked about this whole time, views this as an area where they talk about strict compliance.
Right.
And you need to itemize that.
Right. And you have a lot of arguments. I've had this discussion with attorneys about whether punitives must be itemized or need to be itemized, how punitives are different from compensatory damages because they serve a different purpose. They're designed to punish rather than to compensate for harm. And also, if a jury awards punitive damages, the trial court has authority to reduce that amount. There's a constitutional element of excessiveness that's involved. And even a de novo, which means the de novo review means the Court of Appeals and the Supreme Court can look at that anew and reduce the amount. I get those arguments. Those arguments make sense to me. Itemize punitive damages anyway.
You don't want to be the one
Right.
where you mess that up.
That's right.
So I guess today we've talked about the Fratzke opinion. Hopefully you now understand that Fratzke is a lot broader than just that initial opinion. There's a lot of moving parts on it. I hope we've given you some really good examples of what you need to do. It is not the subject of this podcast. We are going to have a separate podcast on it. But I didn't want the episode to end without mentioning that there is also a rule that talks about your medical expenses. And when you itemize those medical expenses, you need to do more than if you're going to use a summary of those at trial. If you're going to use them at trial, you have to provide those summaries and provide additional information. Again, outside of the scope of today's podcast, but just know we're going to have a subsequent podcast talking about how to appropriately summarize those to make sure you're following those rules. Kevin, any other topics that you want to add today or that you think that we need to know about Fratzke? I'll let you have the last word before we close.
Well, just to briefly summarize, be vigilant about itemizing all of your damages, whether they're compensatory damages or punitive damages. More notice is better than less notice. Regularly update your interrogatory answers with an eye towards itemization of damages. And if you're in a pinch, move for leave to supplement your interrogatory answers.
Well, listeners, with that, we are at the conclusion of episode 4. I hope you found it insightful, and it'll help you in your everyday practice. I want to personally, again, thank the listeners for hanging out with us. Kevin for coming by the studio, Lauren for coming by the studio. We couldn't do this without you. Remember, everyone, you can follow this podcast, and I'm really hoping you'll do that. You can follow us at Apple Podcasts, Google Podcasts, Spotify, iHeartRadio, and many, many others, pretty much wherever you get your podcast. So if you could like, follow, and share, that would be great. And I'm really excited about the upcoming episodes, which you'll get to hear pretty soon. And until then, as always, go try to find one thing that can change the world. And just a reminder to all of our attorneys, these podcasts are always free. But if you want to obtain CLE credit, the Kentucky Justice Association has worked with the Kentucky Bar Association for approval of the CLEs, and the CLEs credits are good up through June 30th of 2024. Again, to get that credit, you simply go to KentuckyJusticeAssociation.org. That's the KJA website. Click on Education and Training, select Podcast, and add it to your cart.